Mr. Ross and Mr. Sikkema, please go ahead.
Good afternoon. Thank you, Mr. Chair. I am Derek Ross. I serve as Executive Director and Legal Counsel to Christian Legal Fellowship, and with me is John Sikkema, Associate Legal Counsel to CLF. We wish to thank this committee for affording us the opportunity to make these submissions. CLF is a registered charity and a national association of over 600 legal professionals who share a commitment to the Christian faith. As an organization of lawyers, we seek to advance justice and the public good by drawing attention to fundamental principles of law. One of those core principles is the sanctity of life, which the Supreme Court recognized as one of our most fundamental societal principles in Carter. That principle affirms that every person's life, no matter how old, disabled, or infirm they may be, has inherent equal worth and value. And as the Supreme Court recognized in Rodriguez, the active participation by one individual in the death of another is intrinsically, morally, and legally wrong. Now, that principle, expressed by Justice Sikkema, was not challenged or overturned in Carter, although Carter does now allow a legal exception to it in certain circumstances. The challenge for us, and for you, the committee, and for Parliament is, how can we best protect and preserve the equal value and inherent worth of all people in a post-Carter Canada? Now, we have framed our submissions in answering that question on the presumption that Parliament will legalize euthanasia and assisted suicide, which we'll refer to as MAID, in certain circumstances, although there are other, and in our view, more appropriate options available to Parliament, which we've explained elsewhere. However, because the bill before this committee takes the path of legalization, we urge Parliament to be forward-thinking and to proactively guard against some of the negative impacts, perhaps unforeseen and unintended, that Bill C-14 might have. Negative impacts that can be at least partially reduced with certain amendments that we and others recommend. We urge Parliament to consider the following questions. How will the legalization of MAID affect our societal attitudes towards suicide? How might it contribute to normalizing suicide as a choice-worthy option, not just in the MAID context, but generally? We know the drafters of Bill C-16 are attuned to this issue, as the preamble acknowledges that suicide is a public health issue, not just a private one. And the Department of Justice's background paper also says that MAID is not being available in wide circumstances because that could undermine suicide prevention initiatives and normalize death as a solution to many forms of suffering. The government is right to be concerned about those potential consequences and needs to be even more deliberate in guarding against them. We need to protect the efforts of physicians, health organizations, and charities to prevent suicide. We are concerned that such groups may avoid steering individuals away from suicidal ideations for fear that they will be seen as interfering with MAID or access to it. This is evident in Quebec, where the College of Physicians recently discovered that emergency room doctors were allowing suicide victims to die when life-saving treatment was available. In media reports, the legalization of assisted death in that province was cited as creating ambiguity about the need to intervene. Parliament must eliminate any such ambiguity here and play a lead role in combating the normalization of suicide. So what specifically can this committee do within the framework of this bill? We say that Parliament should specifically affirm in the preamble to C-14 that suicide prevention remains an important public policy goal. In addition, the preamble should state that sanctity of life remains one of Canada's most fundamental societal principles, that it is not contrary to the public interest to express the view that participating in causing a person's death is intrinsically, morally, and legally wrong, and that MAID should be considered only as a last resort, not a measure to be presented to patients as just another treatment option among others. This, in our view, is an important means of sending a clear signal that even if Parliament chooses to allow MAID, that MAID is not to be seen as the new normal medical response to suffering, or even just one option among and equal to others. This also means that Parliament should protect the charitable status of organizations devoted to preventing suicide, as well as religious organizations and healthcare facilities that decline to provide MAID at their facilities through clear amendments to the Income Tax Act, which we set out in our brief. These amendments will serve to promote freedom of religion, conscience, and expression, but just as importantly, respect and preserve a medical and societal culture in which treatment is promoted as a solution to suffering, not suicide. Similarly, we need to protect patients from being pressured to obtain MAID. Counseling or abetting a person to commit suicide will, wisely, remain illegal under this bill. However, this provision, Section 241A, addresses suicide only and does not seem to address things like voluntary euthanasia, which is considered homicide, not suicide. This may be a drafting error, but either way must be remedied. The reality is that patients will face external pressures to obtain and receive MAID. Bill C-14 acknowledges this. But currently, under the legislation as drafted, when this happens, the only consequence is that a patient may be considered ineligible for MAID, and only if her doctor determines that the request was made because of and a result of that external pressure. And even then, if the physician determines that the patient was ineligible, the patient can still seek MAID from another physician, potentially under continued pressure from that same third party. And the second or 10th or 20th physician may fail to detect the external pressure on the patient. With respect, this is a significant oversight that leaves even the most malicious and prolonged forms of pressure and coercion seemingly free of prosecution. We recommend specific provisions to remove any ambiguity in this regard and make it an offense to counsel, encourage, intimidate, or coerce a person to die by suicide or homicide, including euthanasia. We also urge Parliament to explicitly protect the rights of those who object to participating in MAID, such as healthcare providers. And I know others will be speaking to that matter this afternoon. In legalizing euthanasia, Bill C-14 places the most vulnerable members of society at risk. CLF endorses the recommendations contained in the Vulnerable Person Standard. In addition, we recommend a number of amendments to C-14 to protect the most vulnerable from abuse, which are set out in our brief. It is our submission that the court's ruling in Carter does not preclude Parliament from doing any of these things, and that all of these provisions and amendments are necessary, not only to protect the vulnerable, but to preserve a culture that celebrates the equal and inherent value of every life. Thank you.
Thank you very much.